Good morning, everyone. I will call it an introduction rather than an opening speech. So I'll just go over, since a good number of you will not have particular or detailed knowledge about the Advisory Council or the Legal and Justice Affairs Advisory Council. Let me just give you a recap of the Advisory Council, because it's the formation of the Advisory Council that leads up to the Crimes Proclamation. So about a year or so ago, when the change in governments came in, one of the things that the government did was change its discourse and its orientation towards many things, including human rights and democracy, constitutionalism, and the rule of law. And in that process, one of the first things that the government did was take short-term measures that you could, in human rights legal terms, consider as stopping the violations of human rights. One of the first obligations of the government is to not violate human rights, and that's the first measure they took, which resulted in the release of political prisoners and allowing of media and opposition parties to come into the country. Once those short-term measures were over, the second question is the government faced was, what do they do in order to make sure that this goes on? What's the next step? And that's where the Advisory Council was established, and that's where the Advisory Council came in. It was first formed as an Advisory Council of 13 prominent Ethiopian lawyers who were asked, what does Ethiopia need to do in order to democratize? What does Ethiopia need to do to respect the rule of law and human rights and the constitution and so on? And those 13 lawyers pulled in their colleagues and formed working groups that were composed of subject area specialists. And one of those working groups, and at the end of the day, the number of individuals that are, and by the way, the first 13, the Advisory Council, is composed of volunteers, and all the individuals they pulled in are also volunteers who are asked, Ethiopia wants to democratize, Ethiopia wants to respect the rule of law and so on, what do we need to do in your field? So one of the groups, one of the working groups is the media law working group. And the media law working group, like other working groups, started their work with a diagnostic study of what are the problems that are being faced in that field and how do we solve them. And they resolved that 3 specific laws need to be changed, and they went into the process of drafting a media law, access, computer crimes law, and access to information. So 14 out of the 143 volunteers that work for the Advisory Council have been working for the last year on this on a voluntary basis. And the media law has had a number of public engagements, and the computer crimes law and the access to information law will be able to have public engagement with those legislations, maybe when we do. So I will say that maybe I will be sitting out here if there's a Q&A session. I can add a thing or two. With that, let me invite the member of the working group to talk about specific legislation. Thank you.
We have done a diagnostic study, and more or less we have picked on almost 33 legislations, primary legislations, which deal directly or indirectly with freedom of expression and freedom of media. But obviously, we were not in a position to amend or to make a recommendation on all of these laws. And there are also cross-cutting influences. One law if it's amended in some way, it will also have a good impact on the other law. So what we have done is like we put them in terms of hierarchy, in terms of priority, and with that result we come up with media law, which we suggested to combine print regulation, broadcast regulation, and online media regulation into one. And the other is there has been already criticism on the existing freedom of mass media and access to information proclamation, where do we need access to information as a separate legislation or not, and then there was a decision to make access to information law as a separate law.
I want to point to the issue raised about transparency. I would actually beg to defer to that point, because generally the work of the advisory council, but in respect with the media law working group, this group has taken great measures in order to make this process transparent. One thing I want to point out to you is that the advisory council is an independent body. It's not a government institution. It's not even an institution. It's an advisory body that was established and asked to advise based on the conscience and the expertise of the individuals involved, including the advisory council members and the working group.
In terms of, when we talk about the revision, I think the idea is that, from what Abadi and Salomon said, I think the existing laws, the general legal framework in Ethiopia should be compatible within the framework of any constitutional democratic system. So what does it ask in terms of revising this piece of legislation and in terms of the computer crimes proclamation? What would be the most outstanding issues that should be reformed to fit within an open democratic society, basically? Before I think highlight the specific points of reform, I should say that in noting, of course, within this broader objective, of course, we have looked into specific also documents and made reference. The first thing we did was to prepare what we call a diagnosis report, which included key areas where the public, the media sector, political parties, and the general public at large had serious questions on the issues. So we identified the principal areas of reform in the diagnosis report that serves the basis for reforming the laws, including the computer crime proclamation. Of course, in terms of legal revisions, we also depend on international law. In this case, international human rights are particularly useful because there are certain accepted principles of where the international community expects how our law stands, and we made reference also to this. To some extent, we made reference to also certain NGOs that published, rights organizations that published on the computer crime proclamation. Particularly Article 19 had published a series of recommendations on the reform the law. So, this is, I think, the broader framework of how we try to look into the reform. Maybe I'll just go to the key areas of reform that we thought were very useful in this context. So, one of the challenges of, I think, reforming the computer crime proclamation was that it involves technology in law. So I am an expert in law, but we have tried also to get input from technological people because it does combine. If you look at the provisions, it requires also some technological know-how. But we have tried to in terms of the revision process, to also get feedback from people from the technological field as well. So, Proclamation 958/2016. I have to admit that initially, when I looked at the proclamation, I thought there would be, of course, significant. We have made very significant reforms, I have to say, but it was not completely a bad proclamation, I think, because the date of the adoption was 2016, so it's a modern computer crime proclamation, but it had deficiencies in terms of particularly rights issues, and I will point out some of these concerns. So the first broader serious problem, I think, that we have identified with the computer proclamation was the lack of serious attention to human rights issues. So, looking from the very preambular provisions themselves, I think we have included, of course, many preambular provisions to emphasize on freedom of expression, on due process, and the right to privacy and other issues. But the previous proclamation does not make serious reference to human rights clauses. So, for example, I'll take now, if you look at the models, the different models, including the African Union, the Cybercrime Convention, and the Budapest Convention, they have what they call human rights safeguard clause, a very exclusive clause devoted for lawyers, judges, and practitioners to make reference. In effecting this proclamation, human rights provisions should be respected. So a general kind of backup clause to make reference to human rights. So it doesn't, the existing proclamation does not have it, but most models do have it, and we consider this is just to highlight how human rights concerns were at the core of the previous proclamation. So maybe not directly related with human rights, but one of the things that I think anyone drafting crimes generally should be careful is the risk of over-criminalization. So criminal laws should be very specific and narrowly construed. Otherwise, you risk over-criminalizing and regulating conduct that could be democratic, that could be peaceful. So in articulating, in looking at the specific provisions, what we did was to avoid the risk of over-criminalization. How? By inserting very important clauses. Now, for example, I can give a good example regarding illegal access, illegal interception. So the experts have given recommendation on this issue, and one of the things we said was that there should be a very strong, clear intent requirement in computer crimes. So, for example, the notion of dishonest intent is largely considered as very important in the articulation of computer crimes. So we have included these very high threshold intent requirements in terms of the provisions of the computer crime proclamation. Also, I think the issue of surveillance was and surveillance and interception. These are very scary to human rights activists and human rights practitioners. So one of the things that you see in the law is that interception and surveillance without court warrant was given to law enforcement agencies. So at least what we say was that even if there is a compelling government reason to make surveillance, at least there should be a court. The court should oversee that. So this was revised to fit into within that framework, because courts are required the ultimate, I think, vindicators for any legal dispute, and I think they should have the ultimate say whether the warrant should be to intercept communications or to have surveillance. Also, in terms of the search warrant and the search requirements, search and seizure, it was very broad. It doesn't specify, for example, what kinds of computer data or information should be searched. So we may reference, for example, that the search that the law enforcement agencies should conduct should be the one clearly indicated in the warrant. So not just a generic search, but specifically that is stated in the warrant. So these are very important. One can say these are minor additions, but very important, I think, in terms of their rights, their implications on individual rights. Another very serious defect with the previous proclamation was in Article 37 particularly. It says that the court can shift the burden of proof actually to the accused in certain circumstances, which is, I think, a significant perversion of violation of the basic idea of presumption of innocence. So we completely avoided that. In any circumstance, in criminal prosecutions, the public prosecutor would have the allegation and, of course, the evidence to make a person to be convicted and found guilty. So we never found this to be compatible with the current practice of constitutional democracy. So this was also avoided. So the idea of shifting burden of proof to the accused was very good, I think, in many instances. I don't know if the previous drafters are here, they can justify that, but we thought this was absolutely unacceptable under current circumstances. So absence of human rights safeguard clause, now we have included a specific clause that says a general human rights safeguard clause, what we call, that specifically says that we have added, I should add that in specific articles, there are certain safeguard clauses within most of the articles, but we have also a general clause, a general human rights clause that says that in giving effect to this proclamation, law enforcement agencies and courts, judges, they should refer to, they should make compliance with international human rights standards and human rights standards provided in the Constitution. I should note that this is not even this is not new, like I said, because international instruments also provide for that. I think there is greater also moral authority to put this clause in the new conflict crime proclamation. Another very significant, and I'm very proud to say this, one of the most significant legal changes we made is regarding defamation. So at least in defamation issues in the media, both in the media proclamation and in the computer crime proclamation, we have come to the consensus that at least incarceration or imprisonment should not be a form of punishment for defamation. I think for any media activist that has faced the potential of imprisonment before the existing laws, this we think is a game changer, I think, because not only, I think one has to also see not just the technical change in terms of avoiding defamations not to result in imprisonment, but also in freedom of expression discourse, there is what we call the notion of chilling effect. So the chilling effect doctrine is that when you prohibit laws, if people don't know if they have the risk of imprisonment, and if the laws are, let's say, broadly articulated, people will fear because to speak because of the broader climate of over-criminalization in the law. And I think it will have a significant impact in that regard, and we may change to the defamation clause in the computer crime proclamation, in the media proclamation as well. Another issue, this is more controversial, that we have provided is also to expand the range of crimes articulated in the computer crime proclamation. So, for example, this may be a good thing or a bad thing. It's a good thing. I'll try to justify why it's a good thing. For example, one of the most common computer crimes that you see in the world is child pornography, prohibition of child pornography. This is a common crime prohibited, accessing, distributing child pornography. But if you see actually the definition, and this may be very good for child rights advocates, but if you see the previous provision, it doesn't talk, for example, about virtual child pornography, which is a new form of the ILO works on the international, the agency working on crimes, works on this, but virtual child pornography was not defined in the previous proclamation. It, for example, it also lacks certain elements of crimes, for example, accessing old audio of child pornography. So we have tried to kind of capture these elements of crimes that did not exist before, and we thought that it was very important, I think, given the strong moral reasons, of course, to ban child pornography. The more controversial issue would be, and this is something I think the experts will have some issues to of course, to discuss. We have also added certain crimes. For example, as you know, the online platform is becoming very dominant. So dissemination of false information is already a crime in the criminal law, but for various reasons, for the obvious reasons that this is becoming a very dominant communication, the issue of banning false information is also provided, but with a very clear articulation of what the content of the crime is. So we have made certain additions, including incitement to hatred, incitement to terrorism. These are notions, these are content, of course, based computer crimes, but we thought these are very common. In most countries, these are also regulated, but it justifies the regulation because if the law gives more clarity to the contents of the crimes than, for example, the already existing crime, then people can understand clearly, of course, the boundaries of their rights, and law enforcement officials also will have a better understanding of the contents of the crimes in the computer crime proclamation. So, how am I going to use my time? So, okay. Yeah, 3 minutes. 3 minutes, okay. Another important, I think, addition that we made was in terms of the content limitations on hate speech and also incitement, false information. One of the things we did was that what we call another safeguard clause, which is that with regard to particularly political speech and speech expressions that are made in public discourse, special higher protection should be provided. So we can read perhaps the clause, it's well articulated, I feel, but there is a safeguard clause that says that in the context of political speech, more tolerance is in fact expected from the side of the government. So another safeguard clause on these kinds of expressions. But also I think with regard to other issues, for example, possession of illegal material, criminal, computer data or information that has criminal element is also a crime. But we made, for example, for unintended, if it's for personal use, for professional use, that it should not be punished. So in each of the, almost most of the crimes, you have certain safeguard clauses that we provided that can vindicate individuals not to be over-criminalized. Maybe a last point of reference that I should highlight, and which is a significant addition, is regarding filtering and blocking and internet shutdowns. So this issue is a no man's land. There is no law. The government does as it wants. We don't know the public order or public security justifications that the government uses to shut down, to block, and to filter internet content. So at least our understanding was that if this is done, that there should be due process. For example, that there should be serious public order justification. Second, that any aggrieved party should have a right, of course, to complain to a competent judicial authority to challenge the decisions of the government. This is going to be controversial, I think, but we are very bold enough to put this because we thought it is becoming a serious issue in Ethiopia, and that in some sense the legal provisions should capture this content. So these are, I think, very important. It's a very, I have to say, it's a very technical law, highly technical law. So maybe for the purpose of our discussion, this might be, I think, enough to give us maybe to the Q&A session. Another point, probably the last point I want to say is that in terms of penalties, the punishments for computer crime, if you see the range of punishment for computer crimes, normally for ordinary crimes it's from 1 year to 3 years. In more serious cases, maybe 5 years. If it's a critical infrastructure, of course, it can go to 10 years. But if you see the previous provision, it had, even for ordinary crimes, it goes to 7 years, 5 years. So we tried to make very commensurate, very reasonable, based on international standards and comparative law, that can be commensurate penalties to the already prescribed criminal elements. So these are, I think, some of the reforms. I think the public, we will have a public consultation, I assume, at some stage, so the public will have access to it. It's just, it's not really at this stage, and I'm sure the Attorney General's office also has a website, and at some stage it should be, the draft should be uploaded, and we hope to get more insight and more inputs as we go. Thank you.
So, in relation to the process, I would like to raise 2 points. One is in relation to transparency. One is in relation to transparency. The second is in making the overall revision process inclusive. And the third is in relation to the timing, the time that we should spend having the public say. So in relation to transparency, I think it's really vital to make sure that the way how this revision process is done is open to not just experts and a few set of people, but it needs to be opened up, and we need to know more about who's involved in the process. And so there's, I think, a need to make it open.